Good morning. We are going to be sharing bad news this morning. Unfortunately, we have to because we have to prevent the worst from happening. As you can see, I'm going to share my screen in a moment. But what's happening is that the U.S. Supreme Court has made deportation easier. So nowadays, anyone in removal after a factual determination has been made by the immigration judge, the person cannot review it. So pretty much judicial review has been stopped with this Patel versus Garland case. That's what we are going to be discussing this morning, and we are going to share another bad news when it comes to Title 42. Let me go to my first screen. Here we're going to share Patel versus Garland. Okay, so Supreme Court of the United States, Patel v. Garland, Attorney General. Garland is the Attorney General of the United States. So what's happening is that Patel pretty much took his case all the way, right? Patel took his case all the way to the U.S. Supreme Court, and a decision has been made, and the decision is not in favor of Patel. So what happening is Patel came to the United States in the 90s without inspection. And later on, Patel wanted to adjust status on the 245I. I believe we have talked about 245I on my channel. If you don't understand it, please go ahead and watch that video on 245, and you might even be qualified to adjust status on the 245I. Okay, 245I simply states that while you can use an old petition, if you enter without inspection in the United States to adjust status, provided that the petition was approvable by the time of filing as of April 30th, 2001. So that's what Patel had. He pretty much had a petition that was approvable. But unfortunately for Patel, when he was filling out application for driver license, okay, Patel went ahead and clicked or pretty much accepted the fact that he was a U.S. citizen. On the application, you have to be very careful when you're reading your application or completing your application. You have to make sure that you don't make any factual mistake. So Patel went ahead and did that. He made a mistake, pretty much honest mistake. He said that he was a U.S. citizen, and later on, when he was adjusting status, even though he was qualified under 245I, while USCIS found out that they couldn't adjust status because he falsely claimed U.S. citizenship. So then his case went all the way to immigration court. So basically, Patel found himself in immigration court. And in immigration court, the immigration judge decided that out of on a factual basis, after hearing testimony, that it wasn't a mistake. So Patel pretty much intentionally tried to claim U.S. citizenship. Patel disagreed with the immigration judge. Patel went on appeal, BIA, Board of Immigration Appeal, and his case was denied. Then Patel sought review in federal court. Federal court claimed that they don't have jurisdiction. Patel went ahead and sought certiorari, which is like basically asking the U.S. Supreme Court to review the decision of the federal court, which was the 11th Circuit. Okay, then he went ahead and did that, but unfortunately, still the judge pretty much decided that while this is a factual determination made by immigration judge, we cannot come here and review it. So basically, we do not have jurisdiction over this case. And that's it. So moving forward, any factual determination made by the immigration judge cannot be reviewed in federal court or at the U.S. Supreme Court. That's it. So basically, if a factual determination has been made and the case has been denied, this is it. So the person will find themselves deportable uh, and removed from the United States. That's how easy it has become with this Patel versus Garland. You can go ahead and read it just to make sure that you understand what's going on and what is at stake, right? So, what are we supposed to be doing? So, what we're supposed to be doing is to make sure that when we answer questions on the application, whether it's about work without authorization, whether it's about voting in federal election, whether it's about claiming U.S. citizenship when you clearly do not have that, we have to make sure that we don't do that. Because if we do that, even by mistake, well, you can find yourself in removal proceedings. And once the immigration judge makes a determination on a factual finding of something, that's it. You cannot review it. You cannot go to federal court to have them review that decision. You cannot go to U.S. Supreme Court to have them review that decision. That's it. Once the immigration judge make that decision, that's it. So we need to avoid those type of mistakes. And this is a bad news. It is really bad news. And people already in removal proceedings, what I can ask is that if you don't have a strong case at this point in time, it's better to ask for prosecutorial discretion, because what's happening with this prosecutorial discretion is the fact that, well, you can take advantage of it, and then the ICE will pretty much dismiss the case. And instead of just staying there in removal with an order for removal and later on be removed, because with those order of removal, at any time they can execute those. You know what I mean? So prosecutorial discretion is a way out of it, if it applies on your case. And if you want to know more, please 202-751-2180. Call my office. Consultation fees apply, and let me assess your case and see if we can, in other words, help you out, okay, with this prosecutorial discretion going on, with this new memo, Dolly memo. That's the one we're using currently in immigration court. So to make some people cases dismissed, okay? This is very unfortunate, but the moral of the story is that any application, if you do not understand it, it's better to have a consultation and try to understand it, or to have somebody qualified to help you out filling those applications. You can make a mistake, and that mistake can lead to a removal, to deportation. So that's what happened with Patel, which was really an honest mistake, but unfortunately, the immigration judge made a determination, and that cannot be reviewed. In other words, judicial review, that's the end of it, right? When it comes to factual determination, okay? So let's move along with another bad news. We have another bad news. This is a blowout to this Biden administration. So what's happening is that, pretty much what's happening is that the U.S. District Court for the Western District of Louisiana granted a national-wide preliminary injunction blocking CDC from ending Title 42 border expulsions. So we know what Title 42 is. We've explained it before. So basically, what it is in summary is that they can deny at the border, right? Deny entry for, to people asking for asylum based on health concerns. And because of this COVID-19, the Trump administration really used it a lot to actually push people back, like push them away. And then what happened was the Biden administration came to power. They promised a lot of things, which unfortunately they really didn't help a lot with all those promises. But one thing that they promised was to stop Title 42, which they kind of used it before. And then at some point they decided, well, we're going to fight and end it. and it was supposed to be ending tomorrow, May 23rd. That's when they were supposed to end it. But unfortunately, they cannot end it because the federal judge has issued a nationwide preliminary injunction blocking the CDC from ending Title 42 border expulsion. So anybody at the border now trying to get here, ask for asylum, they can be pushed away based on that Title 42 until this administration goes ahead and try to appeal. And it takes time to come up with an argument, to appeal, to go all the way to Supreme Court. Well, really, we know that the Supreme Court was supposed to hear the argument in June, late June. That's when we will know for sure of the fate of Title 42. So, bad news, really bad news, but we have to share those news so that we can prevent the worst from happening. What can you do if you're concerned? If you're concerned about those two bad news, what you can do, really try to consult with a qualifying immigration attorney. They can help you in your journey. You can either call my office or email me. 202-751-2180. Consultation fees apply. We're here to help you on your journey. Okay, you need to take action, because if you do not take actions and you rely on faith alone, it's not going to turn well. So that's what I'm saying. Thank you for watching. Please go ahead and subscribe, share, hit the notification bell, really, so you don't miss anything, because every day we have new court decisions, we have things happening, and we're going to be updating you. Until next time, bye-bye.